This is Law Bites, a podcast with Michael Geist.
George R.R. Martin and more than a dozen other authors now suing OpenAI, creator of ChatGPT. Martin joining forces with authors like Jodi Picoult, John Grisham, Ellen Hilderbrand, Michael Connolly, and David Baldacci to take on the AI giant, claiming it used their books to train its ChatGPT bot without their permission and without compensation.
The intersection between copyright and generative AI has been very much in the spotlight in recent months, as services such as ChatGPT and Stability AI face a range of lawsuits brought by a wide cross-section of artists, authors, and others in the creative sector. Now, these lawsuits may rest on a weak foundation from a copyright law perspective, but as they make their way through the courts, and as governments such as the Canadian government consults on potential copyright reforms, the issue is now very much on the policy agenda. Andres Guadamuz is a reader in intellectual property law at the University of Sussex and has written extensively on this issue. He joins me on the podcast to explain how copyright intersects with generative AI, to take stock of the various cases, and to unpack a recent decision that dismissed most of a high-profile class action against a trio of AI companies. Andres, welcome to the podcast.
Thanks, Michael, for the invitation.
Well, no, the issue of generative AI and copyright has been really heating up in the last number of months. Certainly, ChatGPT about a year ago, really, I think, put it in the public spotlight. We're seeing some countries consult on the issue. That's happening in my own country of Canada, where there is currently ongoing a copyright consultation on a bunch of the issues associated with generative AI. And we've seen a whole series of lawsuits, and that's really what I was hoping to focus on today, as we've seen a number of these class action lawsuits, often involving some pretty prominent authors and creators. I want to unpack a little bit what these lawsuits involve, where they stand. We've got one in particular that sparked this episode, which has been largely rejected, although it might continue. But nevertheless, we'll have a chance to get through all of that. But before we do some of that, there's been a lot of concern, of course, that's arisen around generative AI and copyright, both in some certain respects with the inputs and the outputs. The inputs on the large language models, what goes into so-called teach these systems, and then the outputs in terms of what is produced by these systems. Can you talk a bit about both of those issues? Maybe starting with the inclusion of the works within large language models, and what copyright might or might not have to say about that.
Yes, sure. Large language models like Claude or GPT-4, Llama, there are quite a lot of them now. These require vast amounts of data to be trained, and of course, this training process will depend on each model. There is going to be different ways in which this is achieved. But for language models specifically, you require large corpus of text, and this text is going to be divided into what is known as a token. So a token is not a word as such. It is usually 3 or 4 letters that come together normally in a word. So usually there are like 2 or 3 tokens per word, depends on each word. It doesn't really matter what the text is, but what matters is that the training process involves, it also involves something called a transformer, but I'm not going to talk about that. So what's happening here is that the model requires all this text, and the text extracts the tokens, and the tokens you get some form of statistical information of what token follows the next one. So the text obviously comes from all over the web. It's usually web scraping, Wikipedia, Reddit, blogs, YouTube transcripts, journal articles, code, and in some cases, full books. In 2 occasions, the collection of Gutenberg books, the public domain books, and sometimes potentially pirated books, which has been the subject of some of these cases. So what happens is that all of these works are copied into a database, and this is collected, it's prepared by the machine learning researchers, and then this token information is extracted. And then the training data or the text can be discarded. You don't need it for the model. The resulting model then is data. You could say it's a statistics. It's mostly mathematics, if you want to put it that way. And most importantly, it does not contain the actual text. So a trained model is not like a collection, it's not like a search engine that is actually drawing information. It is mostly statistics. So the copyright question actually comes from the input side is very simple. Is all of this copying works, scraping the web for all of this text? Is it infringing copyright? Is the inclusion of this an infringement of the exclusive rights of the author? That is in the input phase. In the output phase, the copyright question is perhaps a little bit more simple. Has one of the exclusive rights of the author been infringed? So is there an output that resembles or substantially copies an input? And that is also the subject of some of the cases.
We'll come to those cases in a sec. I just want to, I guess, pause for a sec, because I think you've made a really important point that isn't often well appreciated. There's been a tendency to think of the scraping that may take place for the purposes of building a large language model and compare it to a search engine. But as you point out, a search engine is interested in the text itself. It sounds like this system is really interested in extracting information about the text, and the text itself really doesn't play a significant role at all. It isn't learning in the way that we would conventionally think of as learning.
Yes, it is. That is something that it's often overlooked, and I think that there is a certain conceit in some of the cases, if I may put it this way, that some text is more important than other text. When it actually, what's happening is that the training of a model is very democratizing in some ways. A Reddit post or a tweet or a blog post is potentially as important as a very highly rated journal article, let's say, because the accuracy is not the objective of language model. Language is the objective of the language model, the extraction of this information. So something that I keep seeing in these cases is, oh, my book is so important, or my work is so important to this training data that I'm going to sue for copyright infringement, where people that have a large online presence could actually make the same case, because it's possible that their work is also very prevalent. Things like Wikipedia are very, very, very prevalent in the training data, not only in the amount of text, but also in the importance that is given to it. So the training itself actually gives weights to information, and web scraped data tends to have much more of a weight. It's something that it's always missed, I think.
Okay, that's interesting, and we've seen that some of those exact claims raised, you're right, by certain creators. We see it from the media sector, with this notion that your AI won't be accurate unless you're relying on some of the accurate information. But you seem to suggest that there are some pretty important alternative factors that actually sort of measure the relative importance, so to speak, of some of that data. That's the inclusion side of what goes into the LLM. We'll come to those cases in just a sec, but just quickly, I suppose there, of course, are also concerns at times about the output. Some people feeling that what comes out of these systems feels so similar that surely it must be a copyright infringement. Can you talk a bit about how some of that thinking has evolved?
Yes, it's been quite interesting with the cases that they haven't actually managed to produce infringing outputs. Almost no case. The only one that has managed to produce a potentially similar output has been one of the code cases. Well, I'll explain which one that is, but which involves computer code or source code. But really what we're looking for is whether or not there has been an actual reproduction of text. And there, in some instances, the research has been conducted that some of the models can memorize text. So obviously it's not copying it. It's like someone memorizing a poem. It usually involves that something that is very popular, like the opening of Moby Dick, the opening of Harry Potter, the opening of some very famous books, and the model will be able to recite some passages. That it has been quite a lot, because usually the only way that it looks at some combination of words is in those texts that are reproduced quite a lot. But that doesn't mean that it's actually reproducing in the sense that it's infringing copyright. What most language models are doing is reproducing or producing an output that is usually a summary of the work. So if you ask for it to reproduce the entirety of, let's say, The Lord of the Rings or Song of Ice and Fire, it's not going to do it. It may recite some passages, but what it can do is provide you with a summary of those books. Those summaries are just like you would find on Wikipedia or anywhere else. So it's not infringing copyright if you summarize a book, for example.
Okay. Oh, that's an important distinction. I think we'll perhaps come to it a bit more when we talk about some of those cases. You've kind of alluded to a few. Can you provide a bit of a landscape of some of the claims that we've seen out there? You know, what are some of the big name cases, and roughly where do many of them stand?
Yes, that's going to be a difficult one, because they're quite a lot. There are a couple of websites that actually have a list of all of the cases. So let's try to class them by subject, but also by claimant. So there is a California law firm that has been quite famous in this space. They have brought 6 different actions. I lose count. Now, they brought the first case against GitHub and Microsoft. This was a code case. The argument is that Copilot, the code making program by GitHub and Microsoft, is infringing copyright of all of the code that has been used to train the system. Then the same law firm brought a case against Midjourney and Stability AI and DeviantArt. That's 3 artists. I think we'll probably talk about that in more detail later. Then there is one against, there are 3 cases from writers against OpenAI, Meta, and OpenAI again. And these are different writers, particularly Sarah Silverman is involved in this one against OpenAI. You could say that they're not going that well, but we'll discuss that potentially a bit later. And then there is one regarding images and photographs between Getty Images and Stability AI. And that's a very interesting one, because it's being, they're suing both in Delaware and in England. So that is going to be a one to watch. And that is, Getty are arguing that Stability used their images to train their artificial intelligence, Stable Diffusion. Then there is another big one between Authors Guild and Meta. I think that this is the one to watch, because Authors Guild has a history in this space. Particularly, they sued Google for Google Books, and they lost pretty much, and it was declared that Google's use was fair use. Most recently, we have Another interesting case from Universal and other people in the music industry that have sued OpenAI and Anthropic for infringement in lyrics. So that's another one to watch. It's the first case by the music industry, and it's involving lyrics on large language models. And then there are others. There are a few other authors suing, et cetera, et cetera. But these ones are the most important, I would say.
Okay, you weren't kidding. There are a lot out there.
Yeah.
So I think your summary is really helpful in identifying, who's behind these cases. It sounds like we really are covering such a wide range of different sorts of content or creativity. What are some of the primary legal claims that they raise? I'm presuming that it's copyright infringement, but what are the sorts of arguments that they've sought to raise in these cases?
Yes, I think that there are some commonalities in most of the cases. So at the core of most of the infringement cases is the argument that whenever a company or trainer or researcher is making copies of a work for the purpose of training, they're doing this without authorization. This is copyright infringement. So almost all of them have that claim. Therefore, it's in the input phase. Some, but not all, contain claims also on outputs. They are claiming that potentially the outputs are infringing their copyright. The argument here is a little bit weird. What they're saying is because they haven't been able to produce in almost none of the cases an infringing or potentially infringing output or something that is similar, substantially similar to their works. What the argument in some of the cases has been is, well, every single output that is produced by these language models, by the image models or anything else is a derivative from the inputs. And I think that's pardon my language, it's a bit bonkers. It's just I cannot begin to say just how weird that argument is. So imagine you're just writing an email using Claude or Bard or ChatGPT. That means that you're infringing the copyright on my blog posts, for example. The argument is just makes no sense. So the other claims tend to fall under sort of ancillary claims. There, quite a few of the cases have a copyright management information or rights management information claim. That is very popular in the US because it usually brings statutory damages. So they're all claiming this. Their argument is that the companies in training have removed rights management information like copyright year and author, et cetera, et cetera. And that is in itself an infringement of copyright thanks to the WIPO Copyright Treaty and the DMCA. There are other claims of vicarious liability. Some of them are arguing negligence, unfair competition is another popular one. And in the case of Getty Images, it's very interesting. They're also claiming trademark infringement, which is the only one of the cases that is both copyright and trademark infringement. But yeah, those are sort of the commonalities. Okay. Sorry, just before I forget, it's important that we don't have evidence of copying in all of the cases. Sometimes the claims is the evidence is that, oh, you can summarize my book, therefore you're infringing copyright. That is the evidence.
There's once again a lot there. It's hard to wrap our heads around all the different sorts of cases and claims. Why don't we narrow down though into a particular case? And you referenced it a few moments ago, but we have seen some developments that's really in some ways sparked this particular episode of this podcast. That's the case against Stability AI, DeviantArt, and Midjourney. Can you talk a bit about the claims and even more where we're at in the process right now, given that we've had an important ruling?
Yes, this is one of those cases brought by this California law firm that this was the second case to be brought. So it got a lot of attention and it got a lot of press because of that. So the case is a class action lawsuit involving three artists. These artists were in the training data, and they knew that they were in the training data because there is a website where you can check if your images, your pictures have been used in training, particularly for Stability AI, in a data set, a German data set called Lion, Laion. This website is called Have I Been Trained? And people can look for whichever images. So three artists went to the website and found some of their images had been used in the training. They thought that this was potentially copyright infringement, and this law firm brought them together, and they sued for copyright infringement, but also, again, rights management, information removal, vicarious liability, unfair competition, negligence, etc., the whole thing. The claims pretty much were as follows. The claimants say, all right, our images are in the training data, therefore you made copies of our work without our authorization, without compensation. That is copyright infringement. The other argument is these models are keeping copies of our works in the model. What the image generators do is like a collage, and this is actually in the complaint, and they say this is a collage, so it takes images, it takes bits and pieces from each of the images in the training data, and it puts them together like a collage. And they said, again, this is the argument that they make, is that all of the inputs are, all of the outputs are derivatives of all of the inputs. And there are a couple of other claims here and there, but again, those are the main ones.
All right, so those are the claims. We have had some progress in the courts. How has the court addressed some of those claims?
When I first read the complaint, I was flabbergasted of how bad it was from a technical perspective. I thought, this is not going to fly. This is not going to go well, because I think that they were getting the technology completely wrong. So the claimants didn't make it easy for them. They actually made it easy for the judge to dismiss some of the claims, particularly because in a really weird move, the two of the artists had not registered the copyright to the U.S. Copyright Office. And of course, in the U.S., that is a requirement if you're going to sue for copyright infringement. So in the case of two artists, the judge just dismissed the case with prejudice, that is, they cannot go back and redo. Only one of the artists remains. Most of the claims were struck down, again, because of lack of evidence. First, there was no evidence presented that any copyright management information had been removed from any of her images. There was no evidence presented that there were any outputs that were produced. So there was no reproduction. There was no evidence that her rights of publicity or there was unfair competition, etc., etc. So the judge dismissed all of this with leave to amend, but I find it difficult to believe that most of these are going to be amended. The one claim that remains is that the input claim, pretty much. Her pictures were used in the training data, therefore it's copyright infringement, and that is potentially the only claim that is going to be to go forward. So at this stage, we are at the process the stage where the judge has dismissed a few of the claims. They're going to have some time, I think it's a month, to amend the claims, and then potentially the case is going to go forward and is going to explore a very simple copyright question, which is whether or not this is fair use or not. Is the use of these images without authorization, is it copyright infringement or is it fair use? And we don't know what's going to be the result of that one.
Okay, so still there's still one element there, but many of the aspects of a case that you're right did attract considerable amount of attention. I recall when it was first launched, some of the coverage that took place around it have been tossed out for now. You mentioned a wide range of other cases. Do you see at this stage, and I realize each case is going to stand on its own merits, but do you see these moving in a somewhat similar direction? You already highlighted that some of the kinds of claims that you've seen just that don't make a whole lot of sense. Is that where we're headed, or perhaps another way to think about it? What are some of the real pressure points where you think that they are likely to proceed in a significant way through the courts?
Yes, I think that this California law firm, the one that did 5 or 6 different cases, they spread themselves too thin. It's clear that they're not copyright lawyers. There's that can be said. It's just the fact that they filed a lawsuit without registration. That's a rookie mistake. So I think that those cases continue to be quite weak, and maybe they'll make it to trial, maybe not. But I think that the law firm itself has proven that it's outgunned by some of the other lawyers. That particularly the large companies can produce really good representation. So at least the closer of cases, I don't see them having a lot of future. The more serious ones are the ones that, of course, have better representation and they can produce better arguments. Particularly Getty, Authors Guild, and the music industry, I can see those going further than all these other ones. The problem that they have, however, is similar to what is the problem in these other cases. And the problem is that they have yet to produce an infringing output. So their issue is twofold, I think. If you're only going to argue, or if all these ongoing cases are going to rest on the input phase, that is a much easier fair use, fair dealing. I think, for example, in Europe, could have fair dealing for things like temporary copying. But in the US cases, I think that they're going to have a better fair use case because what is happening with the training is that a copy is made of a work, it's put in a large corpus of other works, and it doesn't really have commercial value or commercial competition with the original. So the copies are made internally, they're not shared with or they're not published, they're not shared with the public, they're not communicated to the public in any way. So it's usually an internal process to extract information, and that is going to produce a product, a model that does not compete directly, for the most part, with the works of the claimants. So I think that even if there is a declaration that there was copyright infringement, I can see the damages being negligible, particularly because I think I've pointed this out in a few occasions. Training a model is not an exclusive right of the author, so you cannot stop people from learning from your works. So in the case of, for example, books or text, you cannot stop people from, if they have legitimate access to a copy of your work, to make to extract information from that. And that means that potentially the damages for this, it would be the price of one copy of a book, for example, which I think that is going to be an interesting one.
All right, so I mean that's a really nice look at some of the claims and frankly the weakness associated with a lot of those claims, which really I guess leads me to my last question, and that is, is the courts the right place for this? Now, it's unsurprising that we see these class actions, and based on some of the analysis you just described, perhaps somewhat unsurprising that we're seeing some of them knocked down as well. I mean, essentially, much of the activity is not infringing when you get right down to it. That suggests that we may well see conversations that move in a different direction, and it won't be about what takes place in the courts, but rather to say, well, if the law doesn't cover this, then change the law. Where do you see this playing out? Do you see it becoming an issue that does get resolved by the courts, and that there are some limitations posed here? Is it more likely that we see this play out through regulation in different kinds of jurisdictions, where there is yet another battle, in a sense, over copyright reform, this time over works and their interaction interface with AI?
Yes, this is a really difficult one because it may depend on a few factors. I think that there are already some technical solutions that are emerging. So in the case of art, for example, there are a few tools where artists can sort of poison their artworks so that they're not trained by an artificial intelligence. There is a growing number of opt-outs where people are using sort of an equivalent to robots.txt that is present in most websites, where you can tell the AI not to scrape your website. Quite a few press organizations particularly have been doing this already. The Guardian, for example, removed itself from the common crawl, which is one of these crawls, web crawls that have been used heavily in the training of some of the models. So there are some technical aspects and practices that are emerging. There is already some of the companies are starting to say, okay, if you want to opt out, we'll remove you from future training, or there are also some technical tools where you can potentially remove existing works from, some works from existing models. So we're seeing potentially technical solutions emerging that could bring us forward instead of relying on some of these cases. I think also there is potentially going to be quite a lot of negotiation taking place, where some companies or some content creators are going to say, all right, we want to enter into agreement with you. We provide you access to our works, and in exchange you can probably give us a licensing agreement with, so that we can use some of your technology for free, or reduced price or something like that. So I can see quite a few ways of where this can play out. I keep thinking back to the early days of the internet. New technologies usually come together with a large number of copyright infringement cases. That was the case with peer-to-peer, with the early internet, et cetera, et cetera. But eventually things sort of settled down. And I think that it may be a combination of technology, common practices, but also potentially just regulation as well.
Yeah. All right, that's interesting. We first got to know each other during those earlier times, and I have to admit that as we've gone through this, as we've worked through this conversation, I can't help but think back to some of those times where we did see, as you suggest, a spate of lawsuits, all sorts of legislative reform, and while some of that continued to play out, things ultimately did settle down through, I guess, a combination of some of the cases, sometimes legislation, and sometimes the practical reality of where the technology and some of the business models went.
It's not possible for industries to emerge or to continue with constant litigation. We've seen this over and over and over again. Even though there is an incentive for some of the content creators to continue to try to maximize their profits, usually what happens is that the technology tends to win out because people find it useful. And if people find it useful and they're using the technology and the search engines or in this case, the large language models, it's not going to be in the best interest of the public to continue with all of this eternal litigation. I think that we'll probably see 4 or 5 years of some of these cases sort of playing themselves out, and eventually we'll get a strong declaration either way.
Yeah. All right. Well, I mean, this is definitely an area that I think in many ways is going to dominate much of the copyright discussion in the coming years. I was part of an AI conference that was put on here at the University of Ottawa. And the comment that was made at one point was that copyright is interesting again, in part because of, in large measure, because of some of these kinds of issues. So there's going to be a lot happening. You've done a fabulous job, I think, unpacking where some of this stands, and perhaps we'll have the chance to come back and revisit how some of this started to play out in the months ahead. So Andres, thank you so much for taking the time to join me on the podcast and talk a bit about copyright and generative AI.
Thanks very much again for the invitation.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.